Those are questions I think that had to be resolved by a jury. I don't believe that I can resolve it at this point. And do yours. Really, Vincent? Seriously, you just throw your case on the table? No, never mistake my courtroom for your home. All right. Court calls the case of the people of the state of Michigan versus Michael O'Leary.
Michael Vincent on behalf of Michael O'Leary.
Right, this is the date and almost time for the continuation of preliminary examination in this matter.
Absolutely. Just to confirm, we are on YouTube, correct? Thank you.
Sure. Yeah.
At the last hearing, the people said I do not have any additional witnesses. Deputy Corona is here.
Mr. Benson.
Yes, I'd like to call Deputy Corona to the stand.
Did he? Benson? I wasn't listening. All right. Sir, please come forward and be sworn.
Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. See, state, spell your first and last name for the record, please.
Matthew Corona, MATTHEWKORONA.
May I inquire?
Deputy, how long have you been a deputy?
On the road 5 years.
Prior to that, jail?
2 years. Approximately.
Okay. And you've, last 5 years, worked the road,
Yes, sir.
taking calls.
Yes, sir.
On February 9th, it started at the 9th and went into the 10th. Is that fair?
I started at midnight, so. At
Okay. Did you take a call at that address?
sir.
Did you encounter a Jessica Kirkland?
Yes, sir.
And did she make several reports to you about a variety of incidents that she had with Michael O'Leary? Now I'm going to ask you about some of those. Were one of those incidents, and it's in the police report, page 11 of your report, I want to refresh your memory.
Do you want me to move it up to a mic? Is that?
Well, maybe I just read it to them and be agreed with. It says in your report, Michael punched her in the head several times, Michael O'Leary. Is that correct? You remember taking that report?
I remember having that report. I can't say that set that report in my report. Yes, sir.
I'm reading it verbatim to you.
Yep.
And would you agree with me that Michael O'Leary is about 6 or well over 200 pounds?
Approximately, sure.
Okay. And Ms. Kirtland, more than one time told you that she was punched in the face, correct? Head in the face. Okay. Did she say both head and face?
I don't know.
Okay. Have you seen people who got punched in the face during 5 years on the road?
I would say so, yes.
Have you seen people who got punched in the face by a man 6'4", approximately well over 200 pounds? Do they, assuming the punch lands squarely in the face, is it your experience that causes severe injury?
Strong.
That's wrong.
I can't say it always happens or it doesn't always happen.
Does it happen? Sometimes so.
I'm sure it does, yeah.
And in your experience, have you seen people punched in the face by a large man several times? If you can't recall, that's fine. Okay. All right. You heard a report that she was dragged or ended up near a stump.
This is the moment where the defense subtly changes its strategy. Instead of immediately arguing that the alleged assault never happened, counsel begins examining how thoroughly law enforcement investigated the claim. That distinction matters. At a preliminary examination, the judge is not deciding guilt beyond a reasonable doubt. The court is determining whether there is enough evidence to justify sending the case to trial. Because of that lower legal threshold, exposing weaknesses in the investigation can be just as valuable as disputing the witness's account itself. Notice how the questioning focuses on whether officers searched for the alleged object, documented the area, or collected supporting evidence. Those questions are designed to suggest that investigators may have missed opportunities to either confirm or disprove the allegation. If jurors later believe the investigation left important questions unanswered, the defense gains room to argue reasonable doubt. At the same time, the prosecutor doesn't necessarily need every unanswered question resolved at this stage. Probable cause can still exist even when an investigation is imperfect. Did you notice that the defense is attacking the investigation more aggressively than the witness's credibility itself? That tactical choice may become extremely important as the hearing progresses.
On her property, which I think is, it's a kind of a half oval shaped driveway, gravel driveway. Do you remember that?
Yes, sir.
And there's a stump somewhere kind of towards the top of that oval near the house.
Somewhere on the property.
Do you remember her telling you that it was laying down there and something penetrated her that was cold? Do you remember? And do you remember her giving you any kind of detail about that?
Besides that it was cold, she wasn't part of my.
She ruled that out, correct? Now, did you ever look for that? You and Sergeant Thompson showed up there also, correct?
Yes, sir.
And there was one other deputy that arrived. As a matter of fact, the deputy who ended up arresting Michael O'Leary. Did anybody look for that? I'm going to call it object.
I did not. I assume that other deputies did because I had an extensive conversation with Jessica.
Did you see anybody looking for that object?
I can't say that for sure.
Do you have any information that that object was recovered? If you did, it'd be in your police report, correct? So nobody told you that they recovered an object, because otherwise it would be in there. It's a pretty comprehensive report, and you'd put it in there. Do you know if a dog was called out to look for that object? Were you informed that Miss Kirtland was on her period or begun her period at that time? Okay, you were told that. Okay. Now, did anybody, to your knowledge, go around that tree stump, walk around it anywhere, and look for that object? You remember a conversation in the barn between you, Sergeant Thompson, and Miss Kirtland when Sergeant Thompson, asked about going to the hospital?
I can't recall.
Do you remember her asking, do you need to go to the hospital? And Miss Kirtland said, no, I've had concussions before.
I can't recall that exact statement, but I'm sure I asked her at one point if she wanted to go.
And then do you remember Sergeant Thompson asking her, no, this would be for a stain kit for an examination that the hospital does for sexual assault?
I don't recall that specific question.
Do you remember her turning down that request? You don't remember that? You remember when you asked Ms. Kirtland, how did Michael O'Leary lose his front tooth? And she told you, I punched it, knocked it out?
Saying she punched him in the face, knocking his tooth out.
Okay. In your practice and training, is it usually the case that people who were sexually assaulted are requested to go to the hospital for a SANE examination? You know what a SANE examination is, correct? Which is a specialized nurse looks for signs of penetration of a woman's vagina. In your training experience, you recall that being the protocol? So it wouldn't be unusual for her to be asked to have a SANE examination. Do you know if she ever had a SANE examination? On your police report, I'll dial up the page. There's a section called Domestic Violence Supplement Report. Do you remember filling that out?
I did not know that.
You remember it being included in your report? Do you know who filled that form out?
Deputy,
Pardon me?
deputy,
Did you have a chance to review it? You remember on there's like a breakdown of victim, suspect, relationships, medical treatment, things like that. You're familiar with the form, obviously. Now, on victim, it's checked alcohol. Would that mean, according to your training and experience, that means the victim had some type of alcohol in her system?
such, yes.
Okay. Also, the word calm was checked. So, do you remember that being checked for the victim? Okay. And down at the bottom, it says medical treatment is checked none. Do you remember that, seeing that? There's talk about consumption of vodka out of a vodka bottle. Did you ever recover the vodka bottle?
No.
There's an accusation that the security system was messed up, tinkered with, destroyed, and so I don't know exactly, but ruined or wrecked that missed. Excuse me. Ms. Kirtland said that her security system had been destroyed by Michael O'Leary. Do you remember that? Was the security system ever recovered? You know if it was fingerprinted? Do you know that there was I forget exactly what you call them, those door cameras that record people going up to the door? Do you remember seeing that at the house? So nobody got a hold of a door cam, correct? To your knowledge? Okay. Now, there also was an accusation while Miss Kirtland was laying down by this tree stump that a motor vehicle came up to her so close that the bumper hit the tree, not her, hit the tree. Did anybody look around and take pictures of the tire tracks there?
I don't recall saying that a truck hit a tree, but I can also say I didn't look for tire tracks.
Nobody looked for tire tracks.
Not to my knowledge, I didn't.
Now, the weather conditions there, even though it was February, there was no snow on the ground, correct? And did anybody take pictures of the truck tire to see if there was grass on it?
I know I didn't.
Within the report, there were several mentions of her hair being pulled. The photographs that I've looked at, and I imagine you've looked at, shows Miss Kirtland with long hair. Did anybody collect any hair that was pulled out of her head?
I did not collect any loose hair.
Did you see any loose hair around?
I didn't observe any.
Did you look on the couch in the living room? Did you look in the truck? And nobody reported to you, I have a bunch of long brown hair. You're right, could I have a minute?
Yes.
So as far as you, there was no investigation on whether or not a large truck, there's a large truck we're talking about, correct? Yeah, pickup truck. Large wheels. If you remember, if you don't remember,
I can't recall.
No, it's okay.
That's also to interpretation.
yeah. But as far as you know, there was no investigation of whether or not this large truck went off the gravel roadway onto grass in and around that stump we've been talking about. Okay. Thank you. Coming on your day off.
This hearing begins with a critical witness taking the stand as the defense starts testing the prosecution's investigation. Deputy Matthew Corona is questioned about what happened at the scene and what Jessica Kirkland reportedly told officers. The defense focuses heavily on missing evidence, especially the mysterious object allegedly involved in the most serious accusation. No object was recovered, no search dog was called, and investigators apparently did not document the surrounding area as thoroughly as expected. The questioning keeps exposing gaps in the investigation, while the deputy repeatedly admits he cannot remember key details. Then the defense turns to medical treatment, alcohol, the security system, tire tracks, and even missing hair evidence.
Really? Any questions?
Deputy, is this your report here? Your Honor, may I approach the witness with
You
this
may.
report? Thank you. Brought that up to you because I'm going to direct you to a couple of specific pages. First, I want to talk about the lethality report, the form, that's a standard form that Deputy Knott filled out. Mr. Vincent asked you about the box that is checked with the word alcohol. Do you recall that line of questioning? And Mr. Vincent asked you, does that mean that a victim had alcohol? And then I didn't write out the rest of the question. Do you recall that? And your answer was something along the lines of, I believe so. Do you recall that? When you answered that question, did you understand defense counsel to be, generally speaking, when that box is checked, does it mean that a victim has consumed alcohol? That's how you were answering that question, in the general use.
Yes.
You were not answering that question to indicate that this particular victim had consumed alcohol or was exhibiting signs of intoxication.
That box being checked.
Should not have been checked. Let's talk about the should not have been checked part. When you interacted with the victim, did you observe any signs of intoxication of her? Did you receive any evidence by viewing her or speaking to her that indicated to you that she was intoxicated by the use of alcohol? What about intoxicated by the use of any other substances? Thank you. Thank you for clarifying there. Turning your attention to page 9 of your report, and let me know when you're there. Mr. Vincent asked you a couple of questions. He asked you about the victim telling you that she had been punched in the head or the face, and you said you couldn't recall exactly what you said. Recall this line of questioning? I'm on page 9 of 19. I'm in the last paragraph. And if Your Honor, if I may approach the witness, I can.
Yes, you may.
Thank you. I apologize for my time up there, Your Honor. I'm on
No,
page
it's okay.
9 of my report, and I want to make sure Mr. Vincent
I'm
has
on
the
page
same
9.
copy as me. And he does.
9 is a 39 here.
Yes, it's not the same 9 as Deputy Corona's, however. He's on a different 10. So, Deputy Corona, I have marked a little section there of where I'm at on our page 9 of your report. If you could read that out loud for us.
At which time Michael punched her in the head several times.
Thank you. That's taken from your section of your report where you are outlining what Jessica is telling you, correct?
Yes.
Thank you. I am going to turn to page 10 of my report. I'm still in the narrative of Jessica, so I'm going to come up, if Your Honor allows, to the witness
Yes.
stand. Thank you. You're on page 11, is that right?
Nope, I'm still on 10 now.
Perfect, thank you. So we're all on page 10, and I'm in the second to last paragraph.
Yeah.
And I'm going to start here. Thank you. Mr. Vincent asked you a line of questioning regarding the victim's statement to you about the penetration. Do you recall that line of questioning? I'm on page 10 of your report. I've outlined a specific section for us. Could you please read that into the record?
Michael pulled her shoes off and pulled her pants off and shoved something into her vagina. Jessica was unaware of what it was that was shoved into her, but described it as being cold and knew it was not part of Michael. Jessica confirmed the object.
Thank you. Just again to confirm, that is part of your narrative report of the information that Jessica provided you on scene.
Yes.
Thank you. Turning away from the report, you were asked a line of questioning about whether or not you searched the scene for an object that could have been used to penetrate Jessica. Do you recall that line of questioning? Fair to say there are a few other officers on scene with you.
Yes,
Sergeant Thompson, Deputy Knott, Deputy Lowe was not on scene. Was he in the hospital?
He,
Or sorry,
he went to the scene the night or the day after.
day after. Thank you. Thank you. So he was on scene, just not that night.
Yes.
Thank you for clarifying for me. My apologies on that. You don't know whether Sergeant Thompson or Deputy Knott looked for an object that night. You don't know whether Deputy Lowe looked for an object the next day. Thank you. You were asked a line of questioning about whether you found, I'm going to use the word clumps of Jessica's hair on scene. Do you recall that line of questioning? At any point, did Jessica tell you that the defendant pulled her hair out of her head? If I were to tell you that I reviewed your report, and fair to say that nowhere in your report does it say that she said he pulled her hair out of her head. Thank you. Your Honor, if I may approach the witness with People's Proposed Exhibits 1 through 4. I have already provided these to defense counsel.
Okay.
Yes.
Do you have, is there a stipulation to admission? Or do you want me to lay the foundation?
Yes.
Thank you.
1 through 4 are admitted for
Thank
exam.
you. And I apologize, Your Honor, I'm purposely not using the screens because we're on YouTube and the sensitive nature of these photos. Deputy, turning your attention to Exhibit 1, could you please describe for the court what we're looking at here?
That'd be a picture of Jessica's face. She has some markings to her face as well as her neck and upper chest area.
Now, when you say markings, it would, if I were to use the word injuries, would that be an appropriate word as well?
Yes.
Do you see any type of redness anywhere?
Yes.
Where do you see redness?
On her neck and just above her, the line of her t-shirt.
And what am I seeing here on her nose?
I don't know if that's dirt or blood.
Thank you.
Some type of a foreign object, not skin.
Thank you. Turning your attention to People's Exhibit 2. What are we looking at here?
Jessica, right forearm.
And how about her elbow? Do you see that in the photo as well? What's noteworthy here?
There's redness to her elbow.
Thank you. Turning your attention to Exhibit 3. What are we looking at here?
Jessica's left leg and knee.
And what is noteworthy here?
Say redness to her knee.
And turning your attention to Exhibit 4. What are we looking at here?
Once again, Jessica's face, the inside of her upper lip.
Could you describe what we're looking at here on the inside of her upper lip?
It looks like a large blood blister.
Your Honor, may I approach and present those photos to Your Honor?
Yes.
Thank you.
Thank you.
Your Honor, I have no further questions for this witness.
Can you redirect, Mr. Benson?
This is the hearing's biggest strategic turning point because both sides have now revealed their core theories of the case. The prosecution has used the deputy's report and photographic evidence to reinforce the complainant's account, while the defense immediately pivots back to what it considers the investigation's greatest weakness, the absence of physical evidence connecting the alleged object to the defendant. That isn't accidental. Rather than disputing every allegation individually, the defense is concentrating on the issue it believes creates the greatest uncertainty. Notice another important courtroom strategy here. The prosecutor relied heavily on prior statements documented in the deputy's report to refresh and clarify testimony, limiting the impact of memory lapses during cross-examination. The defense, meanwhile, is highlighting investigative omissions, such as the lack of recovered physical evidence, forensic collection, or scene documentation, hoping to argue that these missing pieces undermine the reliability of the prosecution's theory. From Judge Simpson's perspective, however, the key legal question has not changed. At a preliminary examination, the court is evaluating whether probable cause exists, not whether every factual dispute has already been resolved. Would these investigative gaps create reasonable doubt for you at trial, or are they simply issues a jury should ultimately weigh? That distinction is exactly where this hearing is heading.
We heard earlier when Ms. Kirtland ruled out anything about Michael O'Leary as far as this mysterious or what I don't know what to call it, object you talked about that penetrated her. Were you here for that? Just about, I think a week ago, about a week ago. Okay. Now I've got the same bunch of photos. And you've been asked to look at some of the pages. My copy's all marked up. I refer you to the prosecutor's page 10 of 19. Do you have the report in front of you? Could you look at the first paragraph on top of page 10?
I believe my page 10 is different than your page 10.
Well, I'm looking at the bottom left-hand corner.
Yeah,
It says page 10 of 19.
yes, but earlier when I was asked the question, my 10 was different than.
I understand. I'm asking on this page 10 of 19. Do you have that?
I do.
I'm going to refer you to the top paragraph.
No, he doesn't have that. He can have mine though. I have 2 copies. Let me just get.
We have mysterious, besides mysterious objects, we have mysterious police reports.
Mine also has markings, so you know, but he can have my copy.
I can just read it to them to save everybody some trouble. It says, not the first paragraph, sorry, the middle paragraph. And I'll read it.
Okay.
Michael was still hitting her in the face. Do you see that?
You can see that. I have the same report as him.
Right here. You need my glasses?
No, I see now. I
Okay.
see. Oh, you're not at the beginning. You're at the end of a sentence. Okay. Can I approach and get him on the same? Can I?
Hey, sure. Anything that would help get everybody on the same page as Michael Vincent.
I will admit, it's kind of hard to read it,
No,
but I can read.
we
it.
were all just breathlessly waiting
I'm
for you to
older than
start
her.
reading.
Okay, we're on the same page.
We're all, everybody on the same page.
All right, we are?
Again,
Okay.
Michael was still hitting her in the face. That is understood, I think. That means it was more than one punch because he was still hitting her face. It was still going on. You agree with me?
Make that assumption, yes.
Well, I'm reading what you put in there. And I've looked at these photos. You have them in front of you. I have probably more experience than anybody in this courtroom about getting hit in the face or hitting somebody in the face.
Yeah, that's probably true.
Thank you. And I'll be blunt with you. I mean, I used to box. I was a street cop for years, and I've seen a lot of people his size and even smaller. Stand up there, Mr. O'Leary, so everybody can see how big you are. All right, you can sit down. Somebody his size, I have a grandson who's his size who boxes. You hit somebody in the face, they mess the face up. They'll break a nose, break an orbit, close an eye, the face will be marked up, not a scratch here or there. And there's no sign of that in the pictures. Do you agree with me? The pictures you took, the description I just gave, is that in any of the pictures you looked at?
I can't see bones in the pictures.
Granted, but you can see those eye closed. You can see nose bleeding. You can see swelling after you get hit in the face. It's a big, powerful man.
Not at the exact time those pictures were taken, no.
You didn't see anything like that. When the pictures were taken,
Shut, I did not see it bloody.
that's my question. Thank you. Remarked about her neck. This picture, you got it in front of you. In the police report and in earlier testimony, Ms. Kirtland testified that she was pulled out of this truck. Apparently there was 2 or 3 incursions in the truck where they were fighting with each other. You remember her telling you that? That she got in the truck to prevent him from leaving. And then 2 of them fought inside the truck. She got pulled out of the truck. And she testified she got pulled out by her neck. Now, and you're familiar with the phrase where the head goes, the body goes, right? The marks on her neck, you don't know where they came from, do you? They could have come from being pulled out by her neck out of the truck.
I suppose, but I don't remember her stating that she was pulled by her neck. I have to look at my report with that exact statement.
It's early testimony. If somebody, let's put it hypothetically, just to not put you on the spot about that. Hypothetically, if somebody's pulled out by their neck, particularly a fair-skinned woman, it's going to leave some marks on her neck. Would you agree with that? Thank you. Were you in charge of the scene, or was Sergeant Thompson in charge of the scene once she arrived?
I was the officer in charge.
Okay. So she wasn't actually in, she was there for a supervisor or assisting you. Is that fair?
That's an odd question. I was the officer in charge.
I'm just trying to find out what her role was. I don't mean to interrupt you, but what was her role when she arrived there?
She assisted in the investigation.
Okay.
She's also a sergeant.
I understand. Fully. So do you remember her directing you or anybody else to look around that tree stump for this object? Do you know if she directed anybody? Did you ever hear her say, scour that area for this object? All right, thank you.
Are you done?
Sort
Other questions?
Yeah, all right. Sir, you may step down. Go back to your day off. Oh, thank you.
Thank you.
We can release him, right? He needs to sleep.
Okay.
We can release him. He needs to sleep.
It's okay.
He can leave.
Thank you.
Yes, he's released.
The prosecution now steps in to repair some of the damage created during cross-examination. Using the police report, the prosecutor asked Deputy Corona to clarify statements that may have been misunderstood. The report contains allegations of repeated blows, an alleged penetration involving an unidentified object, and other details in the complainant's account. Then photographs become important. The deputy identifies visible injuries and markings on Jessica's face, neck, arm, elbow, leg, knee, and lip, but the defense is not backing down. The attorney challenges a connection between those injuries and the allegations, questioning whether investigators properly searched the scene. The exchange becomes increasingly tense as the court weighs testimony against the missing physical evidence.
Yes.
Thanks.
Do you have any other witnesses?
Nope.
Any rebuttal witnesses or the people?
Your Honor.
All right, motion.
Thank you, Your Honor. At this time, we're going to motion to bind over the information. However, in the interim, we received the defendant's blood results. I am going to be adding misdemeanor count 8 high BAC. I have provided the additional discovery to that effect to defense counsel, so my office will issue an amended information. However,
With an added count 9 of high BAC.
yes, I apologize. I think I said 8. Yes, added count 9 of high BAC.
Could I inquire if the blood test came back 17 or above?
Oh, I apologize.
Well, it would if it's a high BAC.
No, I apologize. It's a 0.169. I apologize. Thank you.
Is 169?
Yeah, it's the 167. So
167.
I have the 7 and 6.
So it can't be.
Thank you. It's an OWI. Thank you.
Thank you.
Thank you.
Okay. Well, that's all you had to say.
One and only
Don't
time.
look so smug like you did something.
In terms of the motion, thank you, Your Honor. The people will motion to bind over on all of the felonies as written. Thank you.
Your Honor heard the testimony last week and about this mysterious object. My recollection is reviewing the testimony from last week. She never connected this object to Michael O'Leary. We don't know what the object is. We don't know if this type of object exists. We don't know if Kirkland ever had any kind of physical evidence because she refused to go for a SANE test. I have been doing this for a long time. This is not a CSC. I don't know what it is, not a CSE. No effort was made to look for that. The only thing I can put together on that is that they didn't buy this mysterious object any more than I'm buying it. No effort was made, no dog was called, no put a spotlight on the scene, nothing was done. Nobody even looked for it, let alone did a comprehensive search for it. It's clear that testimony, there was a fight between the two of them, at least 2 to 3 times. Great bodily harm. The drunk driving charge, there. So I'm going to object to find over on the CSE. I understand the rest is a question for a jury. Who started the fight? How long ago? Was it really great bodily harm? Those are issues for a jury, but just simply not enough to bind over. There is no proof anything happened to this woman.
Other than her testimony.
Other than her testimony, granted.
Okay.
And I think the testimony is far from credible. She said, this happened. She can't describe anything except it was cold. And she clearly ruled him out. One of the last questions I asked her, we're ruling him out, right? Yes, she agreed with me. Ruling him out. If it's not him, it's not his body in her.
Oh, okay.
Okay? Ruled him out.
Right, but that doesn't mean that it wasn't a CSE.
And also, there's got to be something there to bind a man over on a CSE one, absolutely one with serious charges, when all could be said, some kind of mysterious object that nobody got any kind of proof other than her saying that. And that's it, nothing. That'll be some clue.
But that then becomes a question of fact for the jury, doesn't it?
I think it comes a question of credibility at this stage. I think it's a credibility issue that this court could rule on, that testimony was simply not credible. I've never heard any kind of testimony like that.
Okay,
But
but
the court hasn't either.
there's a lot in this case I haven't heard before, but I'm just saying that I understand your argument, but what you're asking this court to do in that instance is resolve a question of fact. You're not asking me, I mean, and I don't believe that I can do that at this stage. I mean, if somebody were to find her testimony credible, then it's
Well,
what it is.
I'm asking this court to find her testimony not credible and not provable. But I even asked, anybody look at the grass over there? Anybody see that she was laying next to a tree stump? Nothing, absolutely nothing.
You might have arguments regarding the investigation. You might have other arguments regarding what she said, what she is saying. But again, those are questions I think that have to be resolved by a jury. I don't believe that I can resolve it at this point.
I don't want to say this.
But you will.
My question is, her testimony about having some kind of mysterious object penetrate her is simply not credible. It's not proven by any kind of physical evidence at all. And she turned down going to a sanding exam. This woman has court experience. She works for a criminal defense attorney. She's worked in the courts for a number of years. She knows what a stain test is, and she didn't want one. Why? Because she knows it was going to show nothing at all. And that's not what she wanted. She wanted to bury this man. Thank you, Your Honor.
I don't know that I need a response, but if you want to, go ahead.
I really want to,
Okay, go ahead, and you may respond.
but I know when not to mess with this thing, Your Honor. Thank you.
The court has heard the testimony in the case. There isn't a dispute as to the counts 2 through 8 and 2 through 6 to the felony counts. The court does believe as to those counts that people have sustained their burden shown by probable cause that those offenses were committed and that the defendant committed them. As to count 1, the CSC, which is the crux of the defendant's argument regarding bind over, the Ms. Kirkland's testimony. Ms. Kirkland's testimony was very clear in terms of what she experienced and what she said happened to her at that time. She relayed that to the court regarding the penetration by an object. It would seem to me that should she have really wanted to bury this defendant, she could have very easily, if she were making it up, I guess one analysis would have been to say that it was him instead of some object. She didn't do that. She relayed what she had. It doesn't really become an issue of credibility. It becomes an issue of who's going to be believed regarding it, well, whether or not she's believed, because it really isn't a counterbalancing story. So for those reasons, the court believes that that is an issue of fact that needs to be decided by the trier of fact, that being a jury. Court would also find that the people have sustained their burden as to count one, and therefore would bind the defendant over on that charge also.
Mayor, there's mine, Your Honor.
Well,
Can I approach before we address bond?
yes.
But I think we interrupted you. Was there something else before we?
Everybody's been interrupting me. So he's bound over on those counts. You acknowledge receipt of the information waiver.
I have not received it, but that can get to me. I know the charges. He stays mute to those charges.
Defendant having stood mute, waiving formal reading, court will enter a not guilty plea. And yes, as to bond before I set the pretrial date.
We may approach, Your Honor.
Yes.
Thank you very much.
I need an end date. Pretrial will be set
April 30th at 1:30 before Judge Simpson.
April 30th, 2024, 1:30. As to bond in this case, the court looks at the bond. I've heard the testimony in the case, and conceivably the bond might be appropriate, but it's well out parameters of what typically would be set. So I will reduce the defendant's bond. Currently it's set at 10 million cash surety. I will reduce it. I'll cut that in half to 5 million cash surety. Thank you.
Judge Simpson's ruling highlights one of the most misunderstood principles in criminal procedure. A preliminary examination is not a trial. The court's responsibility here was never to determine whether every allegation had been proven beyond a reasonable doubt. Instead, the legal question was whether the prosecution presented enough evidence for a reasonable person to conclude that a crime may have occurred and that the defendant may have committed it. After hearing both sides, Judge Simpson concluded that threshold had been met. The defense devoted much of its closing argument to the lack of physical evidence surrounding the alleged object and criticized what it viewed as an incomplete investigation. Those arguments may still carry weight before a jury, but Judge Simpson explained why they were not enough to end the case at this stage. Questions about credibility, conflicting accounts, investigative shortcomings, and the weight of testimony are generally matters for jurors to resolve after hearing all of the evidence, not for the court to decide during a preliminary examination. The judge also reduced the defendant's bond from $10 million to $5 million cash surety, signaling that while continued detention conditions were adjusted, the seriousness of the charges remained fully intact. The hearing ultimately demonstrates how courts separate probable cause from proof beyond a reasonable doubt, ensuring that factual disputes are decided by the proper fact finder at trial rather than prematurely dismissed. If you found this case as shocking as we did, make sure to...
The hearing reaches its decisive moment when the prosecution moves to bind the defendant over on the felony charges. The defense argues that the most serious allegation rests almost entirely on testimony, pointing repeatedly to the unidentified object, the lack of forensic evidence, and the absence of a thorough scene search. The attorney insists the testimony is not credible and asks the judge to reject the charge. Judge Simpson, however, draws a clear legal line. At a preliminary examination, he explains, the court is not supposed to resolve every factual dispute or decide who should ultimately be believed. After weighing the testimony, the judge finds probable cause and binds the defendant over on the charges. Then comes another major development. The bond is reduced from $10 million to $5 million cash. If you enjoyed this courtroom breakdown, don't forget to subscribe, and turn on notifications. We'll see you in the next videos.